everybody. We'll call the meeting to order. It is officially 1:02. If you please would join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Amy, if you could please call the roll.
Yes, absolutely. Mr. Siebold?
Present.
Mr. Johnson has been excused. Mr. Dawson?
Present.
Ms. King is also being excused, and Ms. Gunchen?
Present.
And also Lydia Caparosa, our solicitor. Thank you.
Thank you. With 3 members present, we do have a quorum. Looking at the agenda, we have no new business items today. As this is a continued hearing, we also don't have a meeting minutes approval from the prior hearing. And on the agenda today is the continued hearing 13333. Amy, if you could read that continuance, and then we'll get started with testimony.
Absolutely. Continuing appeal number 13333 by James Bruno on behalf of Purple Rock LLC concerning a property located at 2104 Hampton Road. Parcel index is 19-62-12-405. Located in an R1 low-density residential zoning district, the appellant is requesting a use variance for a proposed eating and drinking establishment business. Per section 204.1, eating and drinking establishment is not a permitted use.
Thank you. Mr. Bruno, if you had any additional testimony you wanted to provide or any closing statement, we'll confirm that we are opening the record. Thank you. Just state your name.
Yes.
Thank you.
James Bruno. I am the attorney for Mr. Miller, who is the sole member of Purple Rock LLC. First of all, I'd like to start off by thanking the board for the courtesy, the professional courtesy of not only continuing this matter beyond when it really would have been scheduled for the second Tuesday in May, but also agreeing to do a special meeting at this particular time, somewhat off schedule, and that was all to accommodate the fact that I had a personal vacation scheduled. So it's a big, huge thank you, not only on my behalf, but my wife's in particular. So with that, in terms of there being any other information to present in testimony form or anything like that, that's not really the case. I guess what I'd just like to do at this point, call it closing argument, call it my perspective on what's before the board. I'm just going to make a brief closing argument. And it's going to be centered upon what I believe to be the considerations that the board has to reflect upon in terms of making a proper decision in this matter. Although this is in front of the board with respect to the request for a use variance, I think what's been presented to the board makes it a little bit more expansive than that. I see it being 2 things, not only the request for the use variance, but I think the board has to take into consideration whether or not the existing non-conforming use had really been abandoned in this particular case. And then there are 2 ways to go with respect to that second argument. On the land use variance, just again, you've heard everything here. You've had an opportunity to look at packets. I'm not going to go through it all again. There are standards that need to be met in order for consideration to be given to a use variance. I think that there's been enough presentation of evidence there where the board can credibly determine that the use variance is appropriate and consistent with the requirements in the law when it comes to those matters. On the existing non-conforming use argument, there's 2 considerations I think you have to at least reflect on here. I'm going to call one of them an estoppel, and the second one would be reconsideration of whether or not abandonment truly applies to the strict facts of this case. In terms of the estoppel consideration, what I'm talking about there, and it's in the packet, and I believe I also mentioned it during the course of my presentation the last time, among the due diligence that Mr. Miller did on behalf of Purple Rock was get in touch with the city zoning office to determine whether or not whether or not he could reopen an eating and drinking establishment at that particular location. And it's in the packet of documents. We did document the fact that we asked that question of the city zoning office, and we received a response from the city zoning office indicating that it is an existing non-conforming use, and over and above that, there was no mention made whatsoever that that was either somewhat conditional or that there was a time limit to that and when that time limit would expire. So based upon the information, Mr. Miller, on behalf of Purple Rock LLC, purchased the property with the apparent knowledge that he could use the property for his intended use, the eating and drinking establishment. So that's the estoppel consideration in a nutshell. Then in terms of the abandonment determination, abandonment, and I'm sure the board's aware of this, abandonment is more than just ceasing operations. There's also an intent that has to be ascribed to ceasing operations. And when you look at the case law, they put an awful lot of emphasis on the intention. Now, in this particular case, what was really important, and in retrospect, I'm glad I kind of went through the history here because I think it demonstrates it. Mr. Bishop was the last owner of an enterprise that was actually working on the property. He died on March 27th, 2021. So at that point in time, he is the owner of the property. He dies on March 27th, 2021. The history from there of the property gets somewhat ugly from the standpoint of it ends up being sold at a tax sale to an out-of-towner by the name of Guy Leroy, who's in the business of basically flipping these tax sale properties to anybody else who will buy them in some way, shape, or form. So anyhow, he purchases it at the September 2023 tax sale. The deed is not actually deeded into him until February 14th, 2024. So we've got an out-of-towner who's got different intentions, who now has deed ownership of the property as of February 14th, 2024. On top of that, Mr. Leroy has the additional problem of title defects with the property. I'm not going to go through all of them, but the simplest one to just put on the record at this point in time is, according to real estate attorneys, and I'm among them, a property that is sold at a tax sale is per se, it cannot be insured by a title insurance company unless a number of things happen. You know, the previous owner who lost it at the tax sale signing a quitclaim deed to the new owner, a quiet title action being commenced so the court can review the record and determine whether or not all the procedures were followed for the tax sale, with those procedures basically being noticed to the individual or individuals who lost it at the tax sale. So anyhow, Mr. Leroy, before he can offer the property to sale for anybody, let alone to Purple Rock, had to do a quiet title action. The quiet title action, I don't have the date in front of me as to when it commenced, but the final order granting the relief requested in the quiet title action was January 14th, 2025. Within 6 months, a little over 6 months after that, Purple Rock purchases the property from a parent company that is associated with Mr. Leroy. That's July 29th, 2025. So essentially within a year of Purple Rock meeting the definition of owner under the abandonment definition, he is now going through the process with the city of Erie and gets turned down because it's been more than 2 years since there have been active operations at it. Under all those circumstances, it does not appear to be, or I'm requesting that you give consideration to, whether it's a fair application of the definition of abandonment to say that the non-conforming use expired because it was abandoned, given those circumstances. And I'll throw in my last point with respect to this. We had some mention made by the city solicitor at the last hearing, which, by the way, was unsolicited by me or by Mr. Miller, to the effect that abandonment definition, this case may be the one that demonstrates that it may not be precise enough. It may be vague to the point where it doesn't apply to a situation like this, and in the future that abandonment definition may have to be tightened up a bit. For all the foregoing reasons, we feel that an eating and drinking establishment is proper in terms of the laws as they presently exist with respect to both the request for a use variance as well as a determination that the non-conforming use that previously existed does continue to exist under these circumstances. Appreciate your time, and again, thank you for your consideration in terms of holding a special hearing to consider this. Thank you.
Thank you. I do have one question, but before I do that, I would like the record to reflect that Ms. King joined us about 8 minutes after 1 today, just for the record.
Oh, thank you.
Board Member King is here. Relative to your point about intent, was there ever a period of time that this property was advertised as a bar? Like a real estate listing or?
What period of time are you asking me about? When the previous owner owed it and before he died, or once Mr. Miller, Purple Rock?
When Purple Rock was interested in this property, do you have recollection and or evidence that this property was formally advertised as a bar?
By Purple Rock LLC.
When, I don't remember if you said he worked with a realtor or not, but when he was interested in the property,
Okay.
was the property advertised as a bar?
If I understand your question, here's my answer. Mr. Leroy did not advertise it as, hey, here's a perfect place to set up an eating and drinking establishment. All comers, let me know what the let me know what your level of interest is. That was a contact-to-contact type situation, and as a matter of fact, the way I remember it now that I'm talking about it is, again, Mr. Miller sold his ongoing business, kept the liquor license with the specific intent of placing it somewhere else. So he was looking around for places that were available where he could put the license and open up another eating and drinking establishment. Unbeknownst to him and unbeknownst to me, the property was listed at the tax sale. Had either one of us known that, he would have, he probably would have bid at the tax sale at that point in time. And I realize I haven't answered your question. I think the honest answer to your question is there was no public advertising of this property being available as an eating and drinking establishment by Mr. Leroy. It was a matter of Mr. Miller was aware of it, was interested in it, was actually talking to the wife of Mr. Bishop, who was running the place after he died. She shut down operations, and by the time he got back to it, it had already been sold to Mr. Leroy at the tax sale.
Okay, thank you, that's helpful.
Thank you.
The reason for my question is if we're going to deliberate on your intent question, if we reflect back to the previous hearing, the liquor license expired in 2022, and if it's not formally advertised and or out there as an eating and drinking establishment, it makes the intent argument difficult for me.
And I understand, if I could respond to that.
Sure.
And I respect what you're saying. I think you need to look at the intent of Mr. Miller on behalf of Bach Miller Enterprises and Purple Rock LLC. So when he sells the property where his previous eating and drinking establishment is, all right, he maintains the liquor license, all right? Puts it in safekeeping with the PLCB, and he's out looking around. In terms of intent on his part, I think those circumstances certainly merit consideration in terms of demonstrating his intent, and I think that's the critical intention that you're looking for here. I think the other point to make is it's really obvious what the best and almost the sole use of that particular property is, based upon its history of being an eating and drinking establishment for decades, its location, its configuration, the fact that it has a parking lot, so forth and so on. So, I mean, I think there's plenty there to reasonably infer what the intention was at the time of the purchase. And the critical intention being the intention of Mr. Miller on behalf of Bach Miller Enterprises as well as Purple Rock.
Okay.
So, for the estoppel part, do you know, what was the date of the email from Mr. Welch?
I've got it. Jake Welsh email dated April 9th, 2024 to Bruno is Exhibit T in the packet that I gave out, and I do have extras if those aren't available.
Thank you.
You're welcome.
Any other questions from the board?
I'm curious to your definition. You said abandonment and intent is connected.
Oh, okay. How do I tie the two together? When you look at the cases of the appellate courts who've considered the case, your typical fact pattern in these appellate court cases is similar from the following standpoint. There is a cessation of activity for a sustained period of time, whether the ordinance says a year or 2 years, all right? And then the municipality says, okay, you've lost your non-conforming use. It goes through the process, in front of a board, goes in front of the Court of Common Pleas, and ends up going up on appeal. And the argument that the municipality is making is, hey, it ceased existence and had no operations out of that location that had the non-conforming use beyond the period of time where it is fair and where it is a proper application of the law to say, hey, there's been abandonment in this case. Abandonment equals cessation of operations. The appellate courts have consistently said, that's not really the way it goes. The way it goes is it's not abandonment equals cessation of operations. Abandonment equals cessation of operations plus an intent to cease operations. If you'd like, I could give you an example. So let's say you're in a municipality where the definition of abandonment is 2 years, all right? We've got a gentleman who's operating a permissible non-conforming use in a particular locality. And let's not even make it a bar. Let's just say it's a corner store. Operating, non-conforming use, everything's fine. He gets called into military service, spends 2.5 years overseas, all right? So if it's just a matter of, and he has no one to take over the business establishment, he locks the doors for 2.5 years until he returns. He goes to resume operations, and the municipality says, you no longer have the non-conforming use. You've been closed for more than 2 years. The appellate courts have said, you can't do that. You need one other component, and the other component needs to be intention, all right? And the intention is you ceased operations with the intent to cease operations for a period of time in excess of the 2 years in my example here. So in that case, the veteran who spent 2.5 years overseas, is it fair to say that under those circumstances, that veteran has now lost the non-conforming use because they served our country for 2.5 years overseas. And the appellate courts make it clear that, hey, it's got to be what the intention was. The reason he ceased operations is he was called to active duty military service. He served out of the country for 2.5 years, and he could not run the business being in that type of situation. So that's where the intent element comes into it.
And my question to you was the abandonment with intent. And so where do you specify that someone's intention was clearly to keep it as a bar? If someone is dead, where does their intention, or is that your interpretation?
My interpretation would be you've got a pause. I'm going to call it a pause going on here, all right? Because, again, now you start kind of getting into the definition of owner and trying to match that up with intent. You've got a dead owner, all right? You have no way of nailing down the intent. Then you've got an out-of-towner who's got no interest whatsoever in operating the bar. He wants to flip that thing, make a couple of bucks on it, and move on to his next thing. Pardon me?
No intent there either.
There's no way. There's no intent to continue operations consistent with the non-conforming use.
His intention is to flip it.
His intention is to make a buck.
Okay.
All right. Then you have the delay caused by the quiet title action, the legalities of that, delays involved in it, and so forth and so on. The next person you have in line is Purple Rock LLC, Gary Miller, however you want to phrase it for purposes of that. So I think there's a pause in terms of the intent there, because when you look at the abandonment definition, I don't think you can fairly ascribe to Mr. Miller on behalf of Purple Rock LLC the things that happened prior to that. From the moment he purchased the property, it was his intention to use the property as a non-conforming use that had previously been allowed, using it as an eating and drinking establishment.
Thank you.
Thank you.
Any other questions from the board? Solicitor? Okay.
Appreciate it. Thank you.
Is there anyone else to speak in favor of this request? Anyone to speak in favor? Last call. Anyone else to speak in favor? Hearing none. Is there anyone here to speak in opposition to this request? As you come forward, please state your name for the record and then turn to be sworn in by the court reporter.
Jessica Carnes, do you need my address?
Please.
2113 Rudolph Avenue in Erie.
Court reporter, if you could please swear Jessica in.
Yes, hello. Can you hear me?
Yes.
Do you hereby swear or affirm that the testimony you are about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So at the previous hearing, I spoke at length regarding the impact the establishment would have on our neighborhood. I'm not going to repeat those concerns, but to summarize, I discussed the impact the establishment would have on the enjoyment of homes, that economic hardship is not a valid basis for zoning variance, and the implications suggesting the homes in the neighborhood are not valuable enough to be treated with the same consideration as other neighborhoods. Before I continue on with what I have written down, I just want to say that I understand Attorney Bruno gave an example, but in my opinion, the example he gave, the owner intended to come back and open the business. That was not the intention when the business closed. The owner was not around. His wife wasn't able to sustain the business anymore, and ended up losing the liquor license, and obviously to a tax sale. So, I would like to address new information and inconsistencies that have come to light since the last hearing. I believe these points are important for the board and the public to consider. At the City Council meeting on March 18th, Mr. Miller's attorney testified that this establishment would only operate until 11 p.m. each night. However, during the zoning hearing board on April 14th, the proposed operating hours changed significantly. The applicant stated the business would remain open until midnight, Sunday through Thursday, until 1 a.m. on Fridays and Saturdays. When key operational details change between public hearings, it raises legitimate concerns regarding credibility, transparency, and the reliability of information presented to the board and the public. The substantial change in proposed operating hours creates uncertainty about the true nature and intensity of the proposed use. This discrepancy also raises serious questions regarding whether residents and board members are being provided a clear, complete, and accurate understanding of the true nature and extent of the proposed use. The board and the public deserve full transparency. The discrepancy in operating hours raises legitimate concerns regarding how this establishment may ultimately operate if the request for non-conforming use is granted. During the City Council meeting on April 15th, I observed the City of Erie's presentation regarding proposed bicycle safety improvements. As part of the presentation, a map was shown identifying a future proposed bicycle pathway along West 21st Street from Pittsburgh Avenue to Green Garden. I strongly support efforts to improve bicycle and pedestrian safety within our city. Increased traffic associated with this use would further intensify safety concerns for the bike lane, where additional congestion, parking activity, and turning vehicles could create hazardous conditions for cyclists. The proposed pathway will reduce available street parking in the area. This makes the already inadequate parking situation associated with this property even more concerning. In response to the significant concerns surrounding this establishment, a petition was created, which as of this morning had 120 signatures.
There's no rebuttal.
In terms of petitions, the rules of evidence for zoning hearing boards are a little more fluid than traditional court proceedings. So to the extent there's a copy of the petition that you have present, we're happy to accept that. I don't think we need to have every single person who signed it here, but we can take it and consider it for what it's worth.
I didn't print it out, but it is online. I could send the link if that's what you wanted. This large number demonstrates the widespread nature of the community's concerns with a business of this nature being present in an R1 zoning district. The board's decision in this matter will have a significant long-term, direct, and lasting impact on the surrounding neighborhood and the residents who call it home. The surrounding neighborhood has experienced a noticeable improvement in peace and quality of life since the previous establishment closed. Extending operating hours beyond what was originally represented, increased parking limitation, cyclist safety, and community opposition only reinforces concerns regarding this application. For these reasons, I respectfully ask the board to carefully consider the inconsistencies in the appellant's statements and the practical impact this would leave on the residential community.
Thank you.
Any questions?
You could please send the link to
Amy?
Francis.
Yeah, I'll do that right now.
Thank you. Anyone else here to speak in opposition? Anyone else to speak in opposition? Final call. Anybody else to speak in opposition? All right, hearing none. I think we're going to recess for a brief executive session, and we'll be back out on the record. back up to the microphone? We do have some additional questions for you. Thank you. So we do want to clarify the timeline with you. If you would indulge us to clarify the timeline.
Sure.
So the information that you've presented is that in March of 2021, Mr. Bishop passed away.
Correct.
Okay,
Can I get my?
of course.
notes? Yes, March 27th, 2021.
Okay. And then in July of 2022, the liquor license expired.
According to information that I obtained from the zoning office while they were doing their due diligence, yeah, I've got the license expired July 31st, 2020.
That's what's in the record that you've provided.
It's part of the record before you. I don't remember if I included it in my record or whether it's just part of the record the zoning
Okay.
office submitted. But I don't assert that that's inaccurate at all. I would say that, yes, that's accurate.
Okay.
That July 31st, 2022, the license with the PLCB expired.
Okay. And then in March of 2023, the food sales were over and the operations ceased.
That I couldn't answer for you. The only other information I have relative to dates, while it was still in the hands of the Bishop estate, it again comes from the zoning office. I believe they checked with the health department, and the health department made a notation, I believe, July 12th, 2023, that they were doing whatever they do in terms of the health license. And at that point in time, they determined that the facility was no longer being used as an eating and drinking
Okay.
establishment.
Thank you. So then September 2023 was the tax sale to Leroy.
Correct.
February 2024 was the deed transfer.
To Mr. Leroy,
Yes.
correct.
Yep. January 2025, there was a deed transfer to Corinthian Capital.
Correct.
Okay.
And they're tied into Mr. Leroy.
Yes. July of 2025, the deed transfer to Purple Rock.
Correct.
Okay. All right. Thank you.
You're welcome.
You can have a seat. So based on that timeline, it is the opinion of the board that the non-conforming use was abandoned upon Bishop ceasing operations in 2023. So with that, I'm making a motion for us to vote on that non-conforming use. Go ahead, Amy.
Actually, beforehand, is there a
Mr.
second?
Siebold?
I'm sorry. Is there a second? Hold on, Amy.
Yeah, I'll second that.
Thank you. Apologize for jumping ahead. Mr. Dawson?
I vote the same.
Ms. King?
Yes.
And Ms. Gunton?
Yes.
So the board has decided that the use has been abandoned by a 4-0 vote.
So moving on to the second request today, the use variance. Additionally, it is the opinion of the board that the application does not meet the criteria for a use variance. And I will motion accordingly. Is there a second?
I'll second.
So to clarify, that is a motion to deny the use variance.
Thank you.
Okay, Mr. Siebold?
So I would deny.
Motion to deny.
Yes, motion to deny.
Mr. Dawson?
Motion to deny.
Ms. King?
Motion to deny.
And Ms. Gunton?
Motion to deny.
Okay, by 4-0, the motion to deny the appeal has been.
Thank you. With that, moving on in the agenda, we do not have any additional appeals to be heard. We do not have any unfinished business today, and so we'll move right to adjournment. Thank you, everyone.
Thank you.